Welcome back everybody to Land Law. In this lesson we are continuing talking about some of the more introductory elements, some of the sort of introductory issues that we can explore, focusing in this lesson on the types of property which exist. Now this isn't going to be a lesson on the types of property pertaining to, for example, housing. So we're not talking about the distinction between a detached and a semi-detached house or a bungalow. We're talking about the types of property that exist in law, talking about how law treats different property depending on a few key characteristics. We'll look at the distinction between real property and personal property in this lesson, as well as the civil law tradition of movable versus immovable property. So the previous lesson looked at the question of what land actually is and where we can actually essentially delimit the beginning and end to where land actually is. This is often done through the examination of a vertical extension of land. So how high do you go and still have property rights versus how low can you go and still have property rights? This lesson is going to turn our attention away from the concept of the concept of land to the concept of land law. So talking about not only what land is as a physical entity, but what does the law treat as land? And how do we delineate in law between land and different other kinds of property? Now, this is important because some core modules that exist in this particular area, depending on which university you go and study law at, may not treat this as a subject on land law. They may call this property law, and I've always been of the mind that land law is a better interpretation because property law could be a more all-encompassing set of lessons dealing with not only the idea of land, but also the idea of other elements of personal property, like chattel, for example. So as a result of which, I've been calling this series a set of lessons on land law. So we're looking at what land law entails, and we have to make a distinction that is made within the common law tradition of England and Wales between the idea of real property versus personal property. So in English law, this is how we make a delineation between the two major types of property. We sometimes also count intellectual property as a third kind of property. That is only in the sense of how we study these different areas of property law. So you may have a module on land law, you may have a module on the law of personal property, and then you may also have a module on intellectual property law. But that's not necessarily how it is defined and delineated in that kind of way, because intellectual property could also be placed into the category of personal property, at least in the way in which the English law makes this delineation. So we have this distinction here between real property and personal property, and this is not the same distinction that exists in other kinds of jurisdictions. So in England and Wales, we have this idea here of real property versus personal property. Real property is defining things like land. So things like real estate, for example, and personal property defines things that are, well, as you would may probably understand, to be personal property. My laptop, for example, or chattel, even things which are not necessarily corporeal. So things like stocks and bonds, securities in a corporation, and even intellectual property, so things like copyrights and patents. But other jurisdictions make the delineation in a different way. They make a distinction between what they describe as movable versus immovable property. And this is a lot more simple to understand and is a nicer way of delineating it. And it is essentially how you would describe it if you were talking about this definition. Immovable property it essentially includes all property which is unable to be moved. So we can't move, for example, land, unless we are very, very, very strong. And then obviously everything that is not immovable could be movable. And that is what all the other kinds of property that we have that exists. This is a nice way of looking at it. If you cannot move the property in which that you are examining, then we can call that immovable property, and if you can move it, then we call it movable property. This is something of a civil law tradition. However, in England and Wales, in the English law, we have this distinction not between movable and immovable, we have a distinction between real and personal. And the key distinction here refers to the idea of property rights being able to bind third parties. And so realty, the idea of real property, i.e. land, is capable of binding third parties, and such we describe it as real property. Personal property is not, and so as a result includes all of the other kinds of property ownership. It includes goods and chattels, it includes things like patents, like intellectual properties, it also includes securities such as stocks and bonds, debt and equity securities. And so as a result of which, we can essentially talk about the ability for third parties to be bound to a particular, to the rights of a particular type of property, which is, of course, where realty comes in, and then everything else is just described as personal property. But as I mentioned at the start of this lesson, the way in which you would study this at university would be as three clearly distinct modules. You would study this as land law, personal property law, and then probably intellectual property law. You may even describe this as 4 modules if we then talk about things like the law of corporate finance, talking about security ownership of bonds and stocks. But in terms of the distinction, you make a delineation between realty and personal property. But there is one key exception that exists here, an exception that is technically personal property, but which we're going to be studying in great detail in land law. And this is the idea of leases and the leasehold estate. The reason why this is the case, it is because, at least from a historical perspective, the lease in law was described as, or understood to be, a contractual obligation between a landlord and a tenant rather than a right against the land itself. And so as a result of this, you have this quite weird exception that exists where the lease can be viewed as something of a personal property rather than realty, and so it sort of stands out as an example of interest in land, which is personal property and not realty, despite the fact that leases are, of course, definitely within the remit of our study in land law, and we will be talking about leases in a lot of detail in future lessons' time.